morning Jack Turner signed the papers on 5,000 acres of raw Texas land, the sky was the color of hammered copper and the air smelled like cedar and dry grass. He sat in a title office in a folding chair, dressed in jeans and a faded flannel shirt, and he did not look like a man who had just closed one of the largest private land transactions in that county's history. He looked like a man who had finally found somewhere he could breathe. The notary stamped the last page. The escrow agent shook his hand, and somewhere across the low ridge of scrub oak that separated that 5,000 acres from the manicured streets of Crestwood Estates, one of the wealthiest gated communities in all of Central Texas, a chapter of Jack's life was quietly beginning that he had been planning for almost 2 full years. Jack was 43 years old that morning. He had spent the previous 17 years building a regional logistics company from a 2-truck operation out of his garage in San Antonio into a firm that moved freight contracts across 6 states. The money had come, the recognition had come. The stress had arrived first and stayed the longest. By the time his company employed 91 people and occupied 3 warehouses, Jack had developed the kind of persistent, grinding exhaustion that no amount of sleep could fully cure. He wasn't burned out in the dramatic, cinematic sense. He was worn smooth, like a river stone, still functional, still present, but stripped of the rough edges that once made him interesting to himself. He had tried the usual remedies. A vacation to the coast that he spent, answering emails from his hotel balcony, a weekend fly fishing trip he left early because a contract dispute required his personal attention, a series of conversations with a therapist who was perfectly competent but could not ultimately help him articulate the particular hollowness he felt when he sat at his desk on Monday mornings, looking at a week that looked exactly like one before it. He began waking before dawn and sitting on his back porch in Austin, watching the city lights fade as the sun rose, and asking himself the same quiet question he had no good answer for. What exactly was all of this for? The idea of land came slowly, then all at once. A college friend who'd bought 50 acres outside Fredericksburg mentioned offhandedly that he'd stopped needing an alarm clock. A documentary Jack watched one sleepless Thursday night about prairie restoration in the Texas Hill Country made him sit up straight in his chair for the first time in months. He began reading about conservation easements, about native grass restoration, about the economics of sustainable agriculture and wildlife corridors. He wasn't running from something. He was, for the first time in years, running toward something. He sold his controlling stake in the logistics company over an 18-month period, structured the transition carefully, and walked away with enough capital to pursue exactly the kind of project that had kept him up at night for all the right reasons. He wanted to buy raw land. He wanted to restore it. He wanted to build something that would still be standing and thriving 100 years after he was gone. And he had decided, after months of searching from the Panhandle to the Piney Woods, that the parcel outside Crestwood Estates was exactly what he was looking for. The land had been held by a single family for 3 generations before a combination of inheritance disputes and estate taxes made it necessary to sell. It sat in the transitional zone between the hill country and the Blackland Prairie, ecologically significant, geographically varied, with 2 seasonal creeks, a hardwood draw, and approximately 400 acres of native grassland that had never been broken by a plow. The asking price had scared off most buyers. The size had scared off the rest. Jack's real estate broker, a wiry and good-humored man named Dale Hutchins, had walked the property with him twice and spent most of both visits talking about the complications of the neighboring community. The HOA over there runs a tight ship, Dale had said on the second visit, stopping to look across the fence line toward the visible rooftops of Crestwood Estates. Tight as in, they fined a woman $400 because her mailbox post was 2 inches shorter than regulation height. Tight as in, they've sent cease and desist letters to properties that don't even fall under their jurisdiction just to see what sticks. Jack had listened to all of it with the particular patience of someone who has already made up his mind. He turned back toward the open land, watched a red-tailed hawk ride a thermal above the ridge, and said simply, "I'm buying land, Dale, not neighbors." Dale laughed. Jack signed the purchase agreement 3 days later, and from the second-floor window of a white colonial revival home that anchored the northeast corner of Crestwood Estates, a woman named Linda Mercer watched the survey stakes go in and recognized, with a certainty she had no rational basis for, that whoever this new owner was, he was going to be a problem. She said as much to her husband that evening over dinner. Whoever bought that land, she told him, cutting her chicken with the practiced precision of someone who cut through things for a living, is going to have to learn how we do things around here. Her husband nodded without looking up from his plate. He had long since learned that agreeing with Linda early was the most efficient path through any given evening. Linda Mercer had been president of the Crestwood Estates Homeowners Association for 6 consecutive years, and in that time she had built it into something that inspired, depending on whom you ask, either deep admiration or a particular species of quiet dread. The HOA governed a community of 212 homes across approximately 340 acres of rolling, immaculately maintained residential land. The entry gates were polished, brushed steel. The common areas were professionally landscaped and irrigated on a precise seasonal schedule. The rules, and there were many of them, were enforced with a consistency that some residents found reassuring and others found suffocating, though most of those in the latter category had learned to keep that opinion to themselves. In the years since Linda had taken the presidency, the HOA's governing documents had been revised and expanded 4 times. The fine schedule had been updated twice. An architectural review subcommittee had been created, then given formal enforcement powers, then given a dedicated email address and a 2-week response window for all submissions. Residents had been fined for painting their front doors the wrong shade of red, a shade that Linda herself had once approved verbally before a subsequent amendment to the color palette made it retroactively non-compliant. A family on the South End had received 3 notices in a single summer over the species composition of their front lawn. First, for introducing a non-native ornamental grass, then for failing to remove it within the allotted 30 days, then for the manner in which they eventually removed it, which apparently disturbed the visual continuity of the adjacent common border. A retired couple on the west side had contested a parking violation in writing, citing the precise language of the governing documents, and received in return a 5-page response from the HOA's property management company clarifying that, while their interpretation was technically defensible, the board retained discretionary enforcement authority under Section 12, Paragraph C, and the fine would stand. Linda was not, by most outward measures, unreasonable. She was articulate, well-organized, and genuinely invested in the community's appearance and cohesion. She served on the County Planning Commission. She chaired the Neighborhood Watch Committee. She knew the name of every maintenance crew member who worked the common areas and sent handwritten thank you notes at the end of each fiscal year. She believed, and believed it sincerely, that the quality of a neighborhood was a direct reflection of the standards its leaders were willing to enforce. What she was less gifted at was the recognition of where those standards ended and where someone else's rights began. The line had blurred over years of enforcement, and in the blurring, she had come to confuse her authority within Crestwood Estates with something broader and more flexible. When the 5,000 acres next door changed hands, Linda's first instinct was not curiosity, it was jurisdiction. The letter she sent to Jack Turner arrived at his post office box. He did not yet have a mailing address at the property approximately 3 weeks after the sale closed. It was printed on HOA letterhead, signed by Linda in a precise, forward-leaning script, and written in the measured but unmistakably firm tone of someone who expected compliance as a matter of course rather than negotiation. The letter stated that Crestwood Estates maintained certain community standards applicable to properties in the surrounding area, that the HOA had historically worked collaboratively with adjacent landowners to preserve the character of the region, and that as the new owner of the neighboring parcel, Jack would be expected to register his intended land use with the HOA Architectural Review Committee, submit to an annual review process, and pay a community enhancement fee that the letter described as standard for adjacent non-member properties participating in shared amenity protocols. The fee was listed at $2,400 per year. There was a return envelope included. Jack read the letter twice. He passed it to his attorney, a methodical and unflappable man named Robert Finch, who read it once and set it down on his desk with the careful expression of someone identifying a species of animal they had encountered many times before. Jack then wrote his own reply, not through counsel, not on legal letterhead, but in a plain email from his personal account, polite in tone and precise in content. He informed Linda Mercer that his property was not subject to the jurisdiction of the Crestwood Estates HOA, that he was not a member of the association, that he had no legal obligation to register with their Architectural Review Committee, and that he would not be remitting the described fee. He thanked her for reaching out and wished her well. Linda read the reply on a Tuesday morning and sat with it for a long time. Then she called the HOA's property management company. "Get me the contact for our legal counsel," she said. "We're going to need to clarify some things for our new neighbor." The management coordinator made a note. Down the road, on 5,000 acres of cedar and native grass, Jack Turner was marking locations for his first round of soil samples and thinking about where to put the first stock pond. The fence appeared on a Thursday in early spring, about 6 weeks after Jack's polite email response to Linda's letter. He had been on site that morning consulting with a contractor about grading work near the eastern creek bed, and when he drove back along the property's western boundary in the early afternoon, he noticed the post's first bright galvanized steel, freshly driven into the ground in a line that ran roughly parallel to the existing fence, but several feet inside it. Several feet inside the edge of what his survey clearly showed was his property. The posts ran for what he would later measure as approximately 310 linear feet, following the topography of a shallow draw before curving up toward a level stretch of ground that the HOA had apparently decided would make an attractive walking path. Jack stopped his truck. He sat for a moment with the engine running and both hands resting on the wheel, looking at the posts. There was no crew present at that moment. They had apparently finished the post setting for the day, but the disturbed earth and the neat stacks of fencing materials left nearby made the next stage of the project unmistakably clear. He drove back to his trailer on the property, sat down at his folding table, and called a land surveying firm he had already been using for environmental baseline documentation. He explained what he had seen. He asked how quickly they could get a crew out. The lead surveyor, a direct and experienced man named Tom Walcott, said he could have people there by Friday morning. Jack told him to bring everything: monuments, GPS equipment, the full chain of documentation, back to the original parcel records. Tom asked if there was a boundary dispute developing. Jack said, "I need to know exactly where my land starts and theirs ends, and I need documentation that will hold up in a courtroom." Tom said he'd be there at 7. The survey took 2 full days. Tom's crew walked every inch of the western and southern boundaries, cross-referencing the existing recorded plat maps, the original survey monuments placed at the time of the parcel's initial subdivision decades earlier, and the more recent GPS-corrected coordinates from Jack's title documentation. The results were not ambiguous. The HOA's newly installed fence posts and the cleared ground preparation extending behind them encroached onto Jack's property by a minimum of 11 feet at the narrowest point and by nearly 22 feet at the widest. The total encroached area along that stretch of boundary amounted to approximately 6/10 of an acre of land that was, by every applicable legal measure, Jack Turner's property. Tom presented the findings in a formal survey report, signed, sealed, and accompanied by a corrected boundary exhibit drawn to scale. Jack thanked him, paid the invoice without negotiating, and sent a copy of the survey report to Robert Finch with a single note. "They've started. I need a formal notice of encroachment ready by end of week." Robert drafted the letter. It was a clean, factual document, no rhetorical flourish, no expressions of outrage, no threats beyond the legally appropriate notification that continued construction would constitute ongoing trespass, and that Jack reserved all rights to seek appropriate legal remedies. It referenced the survey by exhibit number. It cited the applicable Texas property statutes. It asked for written confirmation of receipt and a stated timeline for removal of all encroaching materials. The letter was sent certified mail, with copies to the HOA's property management company and their legal counsel of record. Linda Mercer received her copy on a Wednesday. According to the community manager who was present in her office at the time, she read it, set it on her desk, and said, "This is posturing. He doesn't know who he's dealing with." The HOA's attorney sent a formal response 7 days later. The response stated that the HOA's improvements were placed in accordance with long-standing community access rights and that the association maintained a legitimate claim to use of the area in question under applicable community covenant frameworks. The fence construction resumed the following Monday. Jack did not call anyone when he received the HOA's response letter. He drove out to the property, parked near the western boundary, and watched the crew finish setting the fence line for about 20 minutes. Then he went back to the trailer, opened his laptop, and began drafting a memo to Robert Finch about expanding the scope of their evidence collection. The letters that followed over the next 2 months came with escalating frequency and increasingly elaborate justifications. The HOA's property management company sent a formal notice of violation, a document that managed to allege, without any apparent awareness of the irony, that Jack's preliminary grading work on his own land represented a violation of community standards applicable to adjacent properties under what the letter called a neighborhood preservation framework. A second letter arrived 2 weeks later from the HOA's legal counsel, written on heavy cream-colored stationery, stating in careful and multi-clause language that Jack's property was encumbered by a set of extended community covenants that predated the current property records, covenants which, the letter claimed, had never been properly extinguished, and which gave the HOA meaningful oversight authority over land use decisions within a defined radius of the Crestwood Estates boundary. The letter listed a series of demands: that Jack cease his grading work pending HOA architectural review, that he submit a full land use plan for association approval, that he halt any construction of structures or water features until a formal community impact assessment could be completed, and that he engage with a mediation process to resolve the outstanding boundary interpretation questions. It was a confident document. It read like something written by people who expected the other side to blink. Robert Finch called Jack after reading it. There was a pause on the line before he spoke. "They're relying on a covenant document," he said. "A blanket community covenant, allegedly attached to the original subdivision plat from the late 1980s. The argument is that when the land you bought was part of a larger planned development parcel, it was encumbered by these covenants, and those covenants run with the land even after subdivision." Jack said, "Is that true?" Robert was quiet for another moment. "It would be true," he said slowly, "if the covenant document they're citing was still legally operative. But based on what they've referenced here, the covenant they're describing was subject to a sunset clause that expired without proper renewal. If the document is what I think it is, it lapsed by operation of law more than 12 years ago. They would need to have renewed it through a formal process, recorded the renewal with the county clerk, and obtained a threshold of property owner consents to extend it." He paused. "There's no record of any of that in the county's public filings. I checked before I called you." Jack let that sit for a moment. "So they're threatening me with a document that doesn't exist anymore?" Robert said, "That appears to be the situation, yes." Jack told him to hold their formal response for now. He wanted to give the HOA more time. Robert asked why. Jack said, "Because right now they've made a legal argument that doesn't work. I want to wait and see what they do next." What they did next was considerably worse than sending letters. Within 3 weeks of the formal legal demand, the HOA's contractors returned to the western boundary and extended their work, not just completing the fence line, but beginning construction of what appeared to be a graded walking path running along the inside of the fence, as well as the excavation work for a small paved parking area positioned on a flat section of ground approximately 60 feet inside Jack's survey boundary. The crew worked during regular business hours. They did not ask permission. They did not respond to a hand-delivered written notice left at the construction site by Jack's site manager, asking them to stop. They came back the next morning and continued. Jack watched this happen. He did not call the police, though he could have. He did not go down to the fence line and confront anyone, though some part of him would not have minded. Instead, he called the aerial survey company he had already retained for environmental baseline photography and asked them to add a series of precise boundary overlay documentation flights to their upcoming schedule. He set up 4 trail cameras with time-stamped recording along the boundary area. He had Tom Walcott's survey crew return to document the new encroachment precisely and update their formal report. He collected everything, he filed everything, he cataloged everything, and when Robert Finch next asked him if he was ready to respond, Jack said, "Not yet, but soon." The HOA filed its lawsuit on a Tuesday in late October. The complaint was lengthy 41 pages, with 16 attached exhibits, and it asked for several things at once: a declaratory judgment that Jack's property was subject to the extended community covenants, an injunction requiring him to cease his land development activities pending association review, an order requiring him to remove improvements he had made to his own land that allegedly violated the neighborhood preservation framework, monetary damages for what the complaint described as diminishment of community character, and an award of attorney's fees. It was, by any objective measure, an aggressive piece of litigation, and it had clearly been assembled with confidence. Confidence of the kind that comes from years of winning smaller fights against people who couldn't afford to push back. The HOA's board voted to approve the filing at a closed session, a vote that was, as later testimony would reveal, conducted without a proper quorum and recorded in minutes that substantially misrepresented what had actually been said in the room. Linda Mercer reportedly drafted the statement that the HOA's community manager released to the local newspaper the following morning. "Crestwood Estates has always stood for maintaining the integrity and quality of life that our residents and neighbors expect." The statement read, "We are confident that the courts will affirm our community's right to uphold those standards." The local paper ran the story on page 3. Linda gave a brief interview to a reporter who covered property disputes for the county beat. "We will prevail," she told him. This isn't about one neighbor. This is about protecting a way of life. Jack Turner was in the process of installing drainage culverts on the eastern half of his property when his phone buzzed with a message from Robert Finch. He read the message, put the phone back in his pocket, and finished the conversation he was having with his excavation contractor about pipe diameter specifications. Then he sat on the tailgate of his truck and called Robert back. Robert described the substance of the complaint. Jack listened without interrupting. When Robert finished, there was a brief silence. "Good," Jack said. Robert asked him to repeat that. "That's good," Jack said again. "If they'd stopped at the letters, we'd have been managing a boundary encroachment dispute for years. Now they've put everything in writing, in a formal filing, in front of a judge, and they've made claims they can't prove. Everything changes now." Robert was quiet for a moment. Then he said, "I've been doing this for 22 years. I don't think I've ever had a client respond to being sued by saying good." Jack said, "Get me a trial date." The discovery process in litigation exists, in theory, to allow both parties to develop and understand the evidence before trial. In practice, it often does something considerably more consequential. It forces people to produce documents they would very much prefer to keep private. The HOA's legal team sent its initial discovery requests to Robert Finch's office in late November. Standard requests for documents related to the property's ownership history, any communications between Jack and the association, and the survey and engineering records Jack had compiled. Robert's team responded fully and promptly, providing everything requested. Then Robert's team sent their own discovery requests to the HOA. What came back over the following weeks, in banker boxes and digital files and deposition transcripts, painted a picture that Robert later described to Jack as considerably more useful than I expected, and I had high expectations. The HOA's financial records, produced under compulsion, showed a pattern of expenditures that had never been disclosed to residents in the association's annual financial summaries. Legal fees for prior disputes, including 2 cases involving boundary claims against other adjacent landowners, had been drawn from the general operating fund without the board votes required by the HOA's own governing documents. A series of capital expenditures, including the fence and pathway construction on Jack's property, had been authorized by Linda Mercer acting alone, without board approval, despite the HOA's bylaws requiring supermajority board authorization for any capital project exceeding $5,000. The pathway and parking area project, per the HOA's own contractor invoices, had cost just under $48,000. The meeting minutes for the board sessions during which these decisions were allegedly discussed contained signatures from board members who, when deposed, testified they had not attended those meetings and did not recognize their own signatures on the documents. 2 of those board members retained personal attorneys within days of their depositions. There was more. A deposition of the HOA's property management company director produced testimony revealing that the extended community covenant framework the HOA had relied upon in its legal demand letters had been identified internally as legally questionable as far back as 3 years before the lawsuit was filed. An email exchange between the management director and the HOA's prior legal counsel, produced in discovery, showed that the prior attorney had explicitly advised the board in writing that the covenant document in question had lapsed and that any attempt to enforce it against adjacent non-member landowners would be legally precarious at best and frivolous at worst. Linda Mercer had been copied on that email. She had responded with a single line, "Thank you for your input. We'll proceed as planned." That email was now Exhibit 47 in Jack Turner's defense file. Robert Finch read it aloud to Jack over the phone on a Thursday afternoon, and Jack listened in silence. When Robert finished, Jack said, "I want to make sure the judge sees that one early." There was one additional development in the weeks before trial. A board member, a soft-spoken retired engineer named Walter Price, who had joined the HOA board 4 years earlier with sincere intentions about fiscal responsibility, called Jack's attorney's office and asked for a confidential conversation. Walter had watched the discovery process reveal things about the association's governance that had genuinely shocked him. He had raised concerns internally and been told by Linda that dissent was not constructive during active litigation. He had then retained his own attorney, which was how he found himself on the phone with Robert's associate one evening, speaking carefully but clearly about what he knew, what he had witnessed, and what he was prepared to say under oath. Robert's team prepared accordingly. The trial began on a gray Monday in February in the district court of the county seat. The HOA's lead attorney was a senior partner named Gregory Walsh, who had a courtroom manner that mixed folksy confidence with occasional bursts of precise legal argument. a style that typically worked well with juries and reasonably well with judges in lower-stakes civil matters. He opened for the plaintiff with a narrative framing of the dispute as a community versus a wealthy outsider who wanted to ignore established regional norms, a man who had bought land next door to a thriving neighborhood and immediately set about doing whatever he pleased without regard for the people around him. It was a serviceable opening. Several of the HOA board members seated in the gallery nodded at intervals. Linda Mercer sat in the front row in a charcoal blazer, her hands folded in her lap, her expression one of measured certainty. Robert Finch's opening for the defense was considerably shorter. He told the judge this was a bench trial, decided by the judge alone, no jury, that the evidence would show three things. First, that Jack Turner's land had never been subject to the HOA's covenants under any operative legal document. Second, that the HOA had knowingly encroached upon Jack's property, constructing improvements on land they had no right to touch. And third, that the HOA had filed this lawsuit while in possession of legal advice, explicitly telling them their claims had no merit, and that the filing therefore represented a pattern of conduct the court should view accordingly when considering the question of attorneys' fees and sanctions. He noted that the court would hear testimony from a former HOA board member who had voted against the litigation and would testify plainly about what he had seen from the inside. He was done in 11 minutes. The judge, a compact and attentive woman named the Honorable Carol Ann Desmond, made a note on her legal pad and said, "Call your first witness, Mr. Walsh." The HOA's case-in-chief took a day and a half. It was anchored by the testimony of their own survey expert, who attempted to argue that the boundary line was ambiguous based on a historical plat discrepancy, and by a legal historian retained to testify about the durability of historic covenant frameworks in Texas property law. Robert's cross-examination of the survey expert began with the production of Tom Walcott's full survey report, GPS corrected, monument verified, filed with the county clerk, and proceeded methodically through a series of questions that established, line by line, the plat discrepancy the HOA's expert relied upon was based on a superseded version of the county records that had been corrected in a formal resurvey conducted in 2004, a resurvey the HOA's expert had not reviewed. By the end of the cross-examination, the expert had acknowledged that if the 2004 resurvey data was accurate, and Robert produced the county-certified copy in evidence, then the boundary shown in Jack's survey was correct. The HOA's legal historian fared somewhat better on direct examination, but on cross, Robert introduced the lapsed covenant document itself, walked through the sunset clause with the witness line by line, asked the witness to confirm the renewal process that would have been required to extend it, and then asked whether he was aware of any recorded renewal document in the county clerk's office. The witness said he was not. Robert asked if that meant the covenant had lapsed. The witness said, choosing his words carefully, that it would appear so. Robert's case-in-chief for the defense occupied 2.5 days and was built around 4 pillars. The first was Tom Walcott, who presented his survey findings with the calm precision of someone who had testified in property disputes many times and knew exactly how to be both completely accurate and entirely comprehensible to a non-specialist. The second was a title history expert who walked through the full chain of ownership of Jack's parcel, demonstrated the absence of any recorded operative covenant encumbrance, and noted that the title insurance company that had issued Jack's policy at closing had specifically searched for and found no such encumbrance, a fact that would have significant implications for the HOA's position. The third pillar was the financial evidence, the unauthorized expenditures, the missing board votes, the forged or at minimum deeply irregular meeting minutes presented through a forensic accountant retained by Robert's team who had reviewed 4 years of HOA financial records. The forensic accountant's testimony was the most purely damaging section of the defense case, not because it was dramatic, but because it was meticulous. Number by number, authorization by authorization, the testimony mapped a consistent pattern of decisions made without proper process, funds spent without proper approval, and disclosures omitted from the financial reports provided to Crestwood Estates residents. By the end of her second hour on the stand, 2 of the HOA board members in the gallery had quietly left the room. The fourth pillar was Walter Price. He testified quietly and directly about what he had witnessed during his time on the board, about the closed session decisions made without proper votes, about the legal advice the board had received and ignored, and about specific conversations in which he had raised concerns and been overruled. He testified that he had been present at the board session where the decision to file the lawsuit was made and that he had voted against it, and that the minutes of that meeting as produced in discovery did not accurately reflect the discussion that had taken place. He did not testify with anger or score-settling energy. He testified like someone who had decided that the truth, stated plainly, was the only appropriate response to what he had seen. When Gregory Walsh cross-examined him and suggested that his testimony was motivated by personal grievance, Walter looked at him with the patient expression of someone who had anticipated the question and said, "I'm here because I believe in following the rules, Mr. Walsh. That was why I joined the board. It's why I'm testifying now." Judge Desmond asked questions throughout the trial with a directness that made the attorneys on both sides attentive. On the third day, during a recess, Gregory Walsh was observed in the corridor, speaking quietly with Linda Mercer for an extended period. Linda's expression during that conversation was described by a court observer as the expression of someone receiving news they had never considered possible. Judge Carol Ann Desmond issued her ruling 18 days after closing arguments. The opinion was 43 pages, written in the clear and somewhat spare style that characterized her work on the bench, and it was not close in any of its principal findings. On the threshold question whether Jack Turner's property was subject to the Crestwood Estates HOA's covenants, the judge found unambiguously for the defense. The covenant document the HOA had relied upon had lapsed by operation of its own sunset clause no later than 12 years before the lawsuit was filed. The HOA had produced no evidence of any valid renewal. The title records contained no encumbrance. The association had known, through its own legal counsel's written advice, that the covenant was legally inoperative. The court found, in language that Robert Finch would later describe as unusually direct for a judicial opinion, that the HOA's assertion of covenant authority over Jack's property had no basis in law and had been advanced in the face of explicit contrary legal advice. On the encroachment question, the court found that the HOA's construction of the fence line, walking path, and parking area constituted unlawful trespass upon Jack Turner's property. The survey evidence was uncontested in its essential facts. The encroachment was not the result of a good faith boundary dispute. It was the result of a unilateral decision to build on land the HOA did not own and had no right to occupy. The court ordered the immediate removal of all encroaching structures at the HOA's expense to be completed within 90 days under supervision of a court-appointed monitor. On the question of the HOA's internal governance failures, the unauthorized expenditures, the irregular meeting minutes, the use of resident funds to finance litigation, the association's own prior counsel had advised against. The court found that these matters, while not individually determinative of the property law questions, constituted relevant background, establishing the context and character of the HOA's conduct throughout the dispute. The court referred these findings to the county attorney's office for further review, noting specifically the testimony regarding meeting minutes that did not accurately reflect the proceedings they purported to document. On the question of attorney's fees, the court awarded Jack Turner full recovery $314,000, finding that the HOA had brought and maintained claims it knew or should have known lacked merit and had done so in bad faith, as evidenced by the internal legal advice it had ignored. The damages for the trespass itself were set at $67,000, reflecting the diminished use of the encroached area during the construction and occupation period, the cost of remediation surveys, and additional compensatory amounts. Linda Mercer sat at. Then she set her pen down on the table very carefully, the way a person sets something down when they are concentrating on not letting their hands do what they want to do. Gregory Walsh began making notes. In the gallery, several Crestwood Estates residents were very still. One woman who had lived there for 11 years and served on 3 HOA committees looked at the person sitting next to her and said nothing. There was, in that courtroom on that February morning, a particular quality of silence that attends the arrival of consequences that were foreseeable and have finally been foreseen. Jack Turner sat beside Robert Finch and listened to the ruling read aloud. His expression was the same expression he had worn on every day of the trial, attentive, calm, not triumphant. When the judge finished and the courtroom began to stir, some of the gallery residents filing out quietly, a few staying to speak in low voices near the back benches, Jack leaned over to Robert and said something. Robert later said he told him, "Good work." Nothing more than that. The aftermath of Judge Desmond's ruling unfolded across the following months with the particular momentum of institutional collapse, not explosive, but persistent, each stage following from the last, with a logic that made the endpoint feel, in retrospect, inevitable. Within 2 weeks of the ruling, 14 Crestwood Estates residents had retained attorneys and filed separate civil claims against the HOA and its individual board members, alleging breach of fiduciary duty, misappropriation of association funds, and failure to disclose material information in the annual financial summaries provided to homeowners. The claims were largely built on the financial evidence that had surfaced during discovery in Jack's case, evidence that had, through the process of litigation, become part of the public court record and therefore available to anyone who went to the courthouse and asked for the file. The county attorney's office opened a formal inquiry within 3 weeks of the referral from Judge Desmond's ruling, focusing specifically on the meeting minute irregularities and the authorization of expenditures without proper board process. 2 of the HOA's former contractors were subpoenaed. The property management company that had administered the HOA for 7 years placed the Crestwood Estates account in a special review status and communicated to the board that their contract might need to be renegotiated depending on the outcome of ongoing legal proceedings. The HOA's commercial liability insurer notified the board that the trespass judgment and related claims might not be fully covered under the existing policy due to an exclusion for intentional acts, and the evidence in the court record, the insurer's counsel noted, made a compelling case that the encroachment had been intentional. Gregory Walsh's firm withdrew from representation, citing a conflict of interest that was never publicly specified, but which most observers connected to the emerging individual liability questions facing board members who also, at various points, had been Walsh's clients in unrelated matters. Linda Mercer retained separate personal counsel. So did 2 other board members. The board attempted to hold an emergency session in late March to address the crisis, but the meeting was attended by only 3 of the 7 board members, the other 4 either having resigned or declined to attend on advice of their personal attorneys, which fell short of the quorum required under the HOA's own bylaws to transact any business. A second attempt, the following week, achieved quorum only because 2 of the recently resigned members agreed to attend as their final official act, a compromise brokered by the property management company, which wanted an authorized board resolution to process certain pending vendor payments before they withdrew from the account entirely. By April, the HOA's reserve fund, a segregated account that was supposed to hold capital for long-term maintenance of common areas and was required under Texas Property Code to be maintained at a specified minimum, had been drawn down to a level that triggered mandatory disclosure obligations to all residents. The disclosure letter, required by state law to be sent within 30 days of the threshold breach, went out in early May. It was 2 pages long and acknowledged, in the careful language of people who had been advised to be accurate, that the reserve fund had been significantly depleted by a combination of litigation costs, the court-ordered trespass remediation, and the pending civil judgments. It stated that the board was exploring options to restore financial stability, including an emergency special assessment. The special assessment proposal, when it reached residents, called for a per-household contribution of $8,200, due within 60 days. The response was immediate and almost uniformly hostile. Several residents organized a recall petition within 72 hours. Linda Mercer resigned from the HOA board on a Tuesday morning in late May. The resignation letter she submitted to the community manager was brief, 3 sentences, noting her pride in her service to the community and expressing confidence that the association would navigate its current challenges with the same spirit of dedication that had always defined Crestwood Estates. She did not appear at any community meeting after that date. By July, the remaining board had retained a restructuring consultant who specialized in HOA governance crises, and the consultant's preliminary assessment shared with residents at a town hall in August was that the association faced a choice between a substantial restructuring plan, including a revised reserve fund strategy and renegotiated vendor contracts, or a vote to dissolve the HOA entirely and transition the community to a more limited deed restriction framework. The resident vote on that question was scheduled for September. The Crestwood Estates Homeowners Association, in its existing form, was dissolved by a vote of its members on a Wednesday afternoon in September, approximately 11 months after it had filed its lawsuit against Jack Turner. The vote was not close. On the western edge of his property, in a meadow that had been native grassland for as long as anyone could reliably document, Jack Turner stood on an October morning and looked out over land that was beginning to show, in tentative and promising ways, the effects of a 1.5 years of deliberate care. The graded walking trails he had built his own trails, on his own land, for his own purposes wound through restored bluestem and switchgrass. The first of the 2 stock ponds had been completed in August and held water through the first dry weeks of fall, its surface reflecting the oak-lined ridge behind it on still mornings with a clarity that Jack had not expected, and that pleased him in a way he found difficult to articulate to anyone who hadn't stood there and seen it. A pair of sandhill cranes had been documented at the pond twice in September. The hardwood draw along the eastern creek had been selectively cleared of invasive species and underplanted with native seedlings, and along its banks, in the filtered light of early morning, there was a quality of quiet that Jack had been chasing, without quite knowing that he was chasing it, for most of his adult life. The ecological restoration plan he had developed with a team of rangeland ecologists called for a 15-year timeline, and Jack was, by his own accounting, solidly on track. The native grass restoration was progressing faster than the initial projections. The seed mixes had established more aggressively than the ecologists had projected, driven by 2 seasons of above-average spring rainfall that had turned the flat upland sections from bare caliche to a dense, rustling sea of grasses by late summer. A local university's biology department had approached him about establishing a long-term monitoring plot on the property, which Jack had agreed to with conditions that ensured the research would remain consistent with his conservation goals. A small barn structure he'd built on the north end had passed every inspection without difficulty, permitted through the county under processes that had been, in contrast to everything that had come before, entirely straightforward. He had plans for a modest guest structure to accommodate occasional educational visitors, ranchers interested in the restoration methods, students, conservation practitioners. Nothing elaborate, nothing that required anyone else's permission. A journalist from a regional magazine had asked to interview Jack in the summer after the story of the lawsuit and its outcome had circulated through the Texas land conservation community and attracted some attention. He had agreed to a limited interview and had answered the journalist's questions with the careful specificity of someone who had thought about what he wanted to say and what he did not. The journalist, at the end of the interview, asked whether he harbored any resentment toward the people at Crestwood Estates who had made the preceding year so difficult. Jack had looked out the window of his trailer at the October light on the grassland and taken a moment before answering. Most of the people over there had nothing to do with any of this, he said. They were residents. They paid their dues. Some of them got hurt by decisions they didn't make and couldn't have stopped. The journalist nodded and then asked the question that had clearly been building throughout the interview. If you had known, when you signed those papers, exactly what you were getting into, would you have still done it? Jack looked at the land for a long moment. The afternoon light was doing something particular to the far ridge, turning it the same copper color the sky had been on the morning he signed the purchase agreement. The fight wasn't the point, he said finally. The land was the point, and nobody took the land. The journalist asked one more question, whether, looking back, he felt that the outcome had been worth it. Jack thought about that for a moment. What I bought here, he said quietly, wasn't 5,000 acres. It was the right to be left alone to do something that matters. That turned out to be harder to acquire than the land itself. But yes, worth every bit of it. The journalist's piece ran in November. It described the property in considerable and admiring detail. It noted the ongoing restoration work, the monitoring partnerships, the long-term conservation vision. It quoted Jack's final answer at some length. The article received a fair amount of attention in the circles where people paid attention to such things. Several ranchers in the region reached out to ask about his restoration methods. A conservation land trust sent a letter inquiring about a possible easement partnership. One email came from a man in Montana who had been fighting a similar battle with a homeowners association for 3 years and wanted to know the name of Jack's attorney. 3 months after the piece ran, on a gray Tuesday in January, Jack was at his kitchen table reviewing a soil amendment proposal from his rangeland team when his phone buzzed with a notification. An envelope had arrived at his post office box. He drove to town to collect it that afternoon. The return address showed a community association management company from a neighboring county, a county he had never done business in, had no property in, and had never, as far as he could recall, had any reason to correspond with. He opened the envelope in the parking lot of the post office, standing in a cold wind with a coffee thermos in one hand. Inside was a letter that began, in the precise and confident tone of people who had not yet learned what letters like this cost, with the words, "Dear Mr. Turner, it has come to our association's attention that you are the owner of property adjacent to our community's boundary, and we wish to discuss certain matters relating to shared regional standards and applicable covenant frameworks. Jack read to the end of the first paragraph. He folded the letter neatly back along its crease and slid it into the envelope. He put the envelope in his jacket pocket. He drove back toward the property in the winter afternoon light, and somewhere on the long, straight county road that ran through the cedar breaks, he began, very quietly, to laugh.